Let's focus on dispute resolution in cyberspace and the concept of jurisdiction. The growth of internet communication has led to rise in cybercrime such as cyber frauds, identity theft, phishing, malware attacks. According to the Kaspersky Security Network report, India had 37% increase in the number of cyber attacks in the previous year alone, and it is anticipated to be more prevalent in the future. This emphasizes the need for more effective, well structured and strict legislative framework for combating cyber crimes. India has predominantly 4 cyber laws which regulates and governs the cyberspace, such as Information Technology Act 2000, Companies Act 2013, Indian Penal Code 1860, Cyber Security Framework. The Information Technology Act 2000. The Information Technology Act 2000 is the only data protection law in India and governs the entire Indian cyber legislation. The Companies Act 2013. The Companies Act 2013 provides for Serious Fraud Investigation Office, the authority to prosecute Indian corporation and their directors on account of cyber frauds. Indian Penal Code 1816 says about both are used to prosecute cyber offences. For instance, section 464 false documentation, 465 for forgery and other. Let's understand what cyber security framework says about. The most trusted worldwide certifying organization, the National Institute of Standards and Technology (NIST) has approved the cyber security framework which provides a standardized approach to cyber security. The NIST cyber security framework includes all necessary rules, standards and best practices for effectively managing cyber related risk. Now understand what important aspects cover under dispute resolution framework in cyberspace. The dispute mechanism is a structured process that addresses disputes or grievances that arise between two or more parties. The diagram says about more dispute management mechanism to understand how to mitigate the risk and how to handle the dispute management mechanism. The Information Technology Act 2000 establishes quasi-judicial bodies such as adjudicating officials to resolve disputes under IT Act. The adjudication officer has the jurisdiction to award compensation as a civil remedy as well as impose fines for violating the laws under Information Technology Act. This authority also has a power to decide liabilities under Civil and Criminal Procedure Code. The Cyber Appellate Tribunal is the first level of appeal which the chairperson and any additional members appointed by the central government. The second appeal may be lodged with the High Court having a jurisdiction within 60 days after the Cyber Appellate Tribunal's ruling has been communicated. The adjudication processes as provided by the Information Technology Act is filing of the complaint to the adjudication offices, notice to the necessary parties containing the date and time of the first hearing is issued by the adjudication offices. On the date provided in the notice explain alleged contravention to the party against whom allegations are made. The 3 possible instances that can take place subsequent to this are: the person against whom the allegation is made pleads guilty, the person against whom the allegation is made show cause why an inquiry should not be held against him or her. The person against whom the allegation is made fails to appear. In that case, the adjudication proceeds with the inquiry in absence of such person. If the situation in point A happens, then the consequences will be the imposition of penalty or awarding of a compensation as per the provisions of the Information Technology Act 2000 by the adjudication offices. If the circumstances provided in point B unfolds itself, the outcomes are the adjudication offices decides on the basis of submission of parties and preliminary investigation in order to determine whether there is a sufficient cause to order an inquiry or not. The adjudication office will fix another date for production of documents or evidence and then finally pass an order on the basis of the evidence presented. The adjudication officers dismiss the complaint on finding no sufficient cause to proceed with it. The adjudication officers have jurisdiction over cases in which the claim for compensation or harm is less than 5 crore. The adjudication officers has the authority to order an investigation into a complaint to any time after receiving it. An officer from the Office of the Controller of Certifying Authorities, for example, CERTIN, or a Deputy Superintendent of Police conducts the inquiry. Now understand the procedure of Cyber Appellate Tribunal. Under Section 48 of Information Technology Act provides for the establishment of Cyber Appellate Tribunal. Further, Section 58 lays down the procedure and powers of the Cyber Appellate Tribunal. Clause 1 states that the Cyber Appellate Tribunal is not bound by the Code of Civil Procedure 1908, but under the principles of natural justice, the Cyber Appellate Tribunal has the authority to regulate its own procedure, including the location of its hearings, subject to the other provisions of the Act and any rules. Clause 2 provides that the Cyber Appellate Tribunal shall have the same power as civil court under the Code of Civil Procedure 1908 when trying a case for the purpose of carrying out its tasks under this Act. Having any person summoned and compelled to appear as well as questioning him under oath, requiring documents or other electronic records to be discovered and produced, receiving evidence on affidavit, appointing commissions to examine witnesses or documents, reconsidering its decision, dismissing an application due to default or making an ex parte decision, any additional matter that the court may deem necessary. Clause 3 provides that any proceeding before the Cyber Appellate Tribunal is to be treated as a judicial proceeding for the purpose of Section 193 and Section 228 of the Indian Penal Code 1860, and the Cyber Appellate Tribunal is treated as a civil court for the purpose of Section 195 and Chapter 26 of the Code of Criminal Procedure 1973. Telecom Dispute Settlement and Appellate Tribunal, in order to bring in functional clarity and strengthen the regulatory framework and the dispute settlement mechanism in the telecommunications sector, TRI Act was amended and TDSAT was established to adjudicate disputes and dispose of the appeals. Further, order issued by an adjudication office are appealable before the TDSAT. A party can appeal against adjudication office's order before TDSAT within 45 days of the receiving the order. A party can file an appeal against TDSAT's order to the High Court within 60 days of the receiving the order. High Court. According to Section 62 of the Information Technology Act 2000, a person aggrieved by the decision or order of the Cyber Appellate Tribunal may file an appeal with the High Court within 60 days of receiving notification of the tribunal decision or order on any question of fact or law arising out of such order. Banking Ombudsman. The Banking Ombudsman scheme is an expeditious and inexpensive forum for bank customer for resolution of complaints relating to certain services rendered by banks. The Banking Ombudsman scheme is introduced under Section 35A of the Banking Regulation Act 1949 by RBI with effect from 1995. SEBI Ombudsman. The SEBI has introduced the concept of ombudsman for redressal of grievance of investors in securities against the listed companies and the intermediaries in the securities market relating to refund to money or securities amount or any claim in respect of dealing in securities or deficiency in service by the intermediaries and other related matters. Issues with the dispute resolution mechanism. The adjudication officers are vested with the wide powers, that is, they have authority to rule on any law, rule, regulation or instruction made under the Information Technology Act 2000. This leads opposing viewpoints on the same subject. There is no guiding document on the cyber investigation or cyber forensic in the Indian regulatory environment. The TDSAT must strengthen itself and include a specialist with expertise in information technology. Cyber appeal should be decided by a different bench for effective dispute resolution. Now understand the important aspect of this chapter. If you want to understand the dispute management, you need to consider India is being a big internet user base must strengthen the dispute resolution structure for combating cybercrimes. Now focus on jurisdiction in cyberspace. The issue of jurisdiction in cyberspace is a perplexing as the internet has no physical boundaries and no restraints. As a consequence, anybody can get trapped in cyberspace anywhere. Cyberspace is the online world of computer networks and internet. It is a virtual platform that is used to facilitate online communication. Cyberspace is vast and boundless, which involves a large computer network made up of many worldwide computer subnetworks that employ transmission control protocol or internet protocol to aid in communication and data exchange activities. Let's take an example. A person develops a social media profile by using another person's name who is a citizen of India. A impersonates himself and uses the social media account under another person's name for sending messages, dealing in products, sending emails and other electronic communications. A, via this profile, committed a fraud by firstly advertising his product online, attracting customers, and after receiving the money, the delivery of the same was denied. Thereby, many such customers from various countries were trapped into this online fraud. Here comes the question of jurisdiction, as in where the complaint will be filed. Let us focus concept of jurisdiction. Jurisdiction is the power and authority of court to hear a case and give a judgment. It is the geographic area over which the legal authority extends to hear and determine the cause of action. It defines the appropriate court in which to bring a particular case. A cybercrime generally involves three parties: user, server host and the victim or the person with whom the transaction took place. The issue arising out of such activity as the foremost contains that of the jurisdiction of a court, which court shall have the jurisdiction to entertain the matter, and then which law shall be applicable in such cases. Now consider jurisdiction under Information Technology Act 2000. Information Technology Act 2000 in section 1 subclause 2 states that the IT Act extends to the whole of India and applies also to any offences or contravention thereunder committed outside India by any person. Further, section 75 states that subject to the provision of subsection subclause 2, the provision of this act shall also apply to any offences or contravention committed outside India by any person irrespective of his nationality. For the purpose of section 1, this act shall apply to an offence or contravention committed outside India by any person if the act or conduct constituting an offence or a contravention that involves a computer, computer system or a computer network located in India. This provides prescriptive jurisdiction in India, that is unlimited jurisdiction wherein a country can enact any law, legislation on any matter, even where the person's nationality is different or the act happened at a different place. Let us focus on Convention of Global Cybercrime. The Budapest Convention of Europe's cybercrime is the sole legally binding International Multilateral Treaty on Cybercrime. It coordinates cybercrime investigation between nation states and criminalize cybercrime activities. It serves as a guideline for any country developing comprehensive national legislation against cybercrime and as a framework for international cooperation between state party to this treaty. This convention has eagerly called for Indian participation since its formation in 2001, but India has decided not to be a party to it. While considering the jurisdiction and dispute resolution activity, what we have understand here? Dispute resolution and the concept of jurisdiction is a debatable topic, as the ambit and scope of cyberspace is wide. Cybercrimes and cyber attacks can occur anywhere at any time and thus are boundaryless. It becomes very difficult to ascertain the jurisdiction. Legislation need to be made progressive to combat cybercrimes and issues relating to their jurisdiction. Lastly, in spite of having a dispute resolution mechanism, we have certain lacunas in it, such as wide and excessive powers of adjudicating officers, lack of expertise in cyber field, and there are more things which need to be updated. Thank you.